It's 9:01 on Wednesday, March the 23rd. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representative Beck, Curcio, Farmer, Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Sexton, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, any personal orders before we begin today? Representative Griffey.
Thank you, Mr. Chairman. I hope you all will all join me in welcoming a group of Stewart County seniors that are here visiting us today and job shadowing us. Job shadowing me is Catherine McGee. Catherine McGee, will you please stand up and let us welcome you? Thank you. Thank you, Mr. Chairman.
You're welcome. Any other members? Our Sergeant of Arms, Mr. Tyler Muniz, with our weekly words of wisdom.
Today's words of wisdom come from Dr. Martin Luther King. The ultimate measure of a man is not where he stands in moments of comfort and convenience, but where he stands at times of challenge and controversy.
Amen.
Very good. Thank you for that. All right, members, we're going to get started. We've got a lengthy calendar again today. If I can direct your attention to item number 29, House Bill 2428 by Chairman Russell. Without objection, that'll be off notice. Item number 48, House Bill 2777 by Chairman Todd is off notice. That'll bring us back to item number 1, House Bill 2524 by Vice Chairman Sexton. We'll need a motion and a second on this. You have a motion and a second. You're recognized. There's Amendment Code 16181. You wish to proceed with that amendment?
Yes.
Motion on amendment.
You have a motion and a second. You're recognized on the amendment.
Thank you, Mr. Chairman. This amendment addresses an issue that we talked about last week with the committee, and there were some concerns about the age limit. So what this amendment does is it raises the age limit to 18, and that should satisfy any concerns that we had there.
All right. Thank you for the explanation. Any questions for the sponsor on the amendment?
Question on the amendment.
Question's been called. Any objections? Seeing none, we're voting on attaching Amendment Code 16181 on the House Bill 2524. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 2524 as amended. We do have several folks here for testimony today. And so without objection, we'll go out of session. And first on our list will be Commissioner Long from the Department of Safety. Welcome to the committee, Commissioner. You'll have, there'll be a light on the front there you can press, and if you will, introduce yourself, and you'll have 4 minutes for comments, and then the committee will be available to ask questions to you.
Good morning, Mr. Chairman. Thank you for the opportunity to come, and it's my understanding that I was asked to come this morning and might answer any questions for the committee, and I'd be glad to answer any questions anybody has.
Well, thank you very much. Leader Lamberth.
Mr. Rushman will say it's good to see you today, you and your staff. You've got a lot of folks here that I recognize and everything. And before we get into questions, just wanted to say thank you for your decades of experience in law enforcement. I know we'll get into some details on a specific piece of legislation, but we're always glad to have you in committee. We don't see you often enough, and glad to just have an excuse to have you down here and to have an opportunity to visit with you. So just wanted to publicly say thank you for help keeping our state safe. We really appreciate it.
Thank you, Leader.
Chairman Curcio.
Thank you, Mr. Chairman. And Commissioner, I echo the leader's comments. It's a pleasure to get to work with you. Thank you for taking time out of your schedule. I'm not the one that requested your presence here today, but I was in committee last week, and so I guess we should just get down to it, which is House Bill 2524 as amended now is before us. We understand that the Department of Safety has some concerns about that. And could you just enlighten this committee as to kind of what the nature of those concerns are and help us understand that?
Yes, sir. Thank you, Chairman Curcio. In reviewing the bill, looking at all the aspects of the bill, we certainly understand the Second Amendment right for people to carry their arms and agree with that. Looking at that, we have tried to compare that with the legislation that this body passed last year. to see the differences in it. And some of the differences that we saw, it opens it up to carry any firearm, not just restricted to a handgun as the current law does. We had concern about the age, and Mr. Sexton amended that to the 18 years of age, so that answers that point. It removes the prohibition on carrying or possessing any other dangerous weapon that we have concerned about. Also, looking at the bill as it's...
I'm sorry, I hate to interrupt, but if I may, Mr. Chairman. Could you give us an example for those of us who maybe don't know of what some of those other types of weapons would be?
Well, as I understand, it could be a long gun, it could be a rifle, it could be any other weapon, because it doesn't say in the bill what it's restricted to.
Okay, thank you.
And I have, if you will expand on that, the other prohibited weapons that you, not specific to firearms, that you referenced.
Well, I mean, it could be axe, it could be any kind of deadly weapon that could be carried, any kind of sharp instrument that could be used as a deadly weapon. What we see in the thing, it doesn't show anything of a dangerous weapon description in it.
Okay, thank you.
Also concerned about some of the restrictions that are under current law that were not under this bill that we saw, such as the stalking, the DUI, a judicially committed individual, a mental defective individual that might have a defect, anybody that would be under a court conservatorship. They're not covered under the law as we saw it. And it didn't include any prohibitions for other state or federal law. And trying to look at this bill and look at some of the federal law, and in particular in possession, in order to purchase a weapon, as we see it, this bill would allow you to possess it, but you wouldn't be able to purchase it, because in the purchase of a weapon, you have to declare citizenship, you have to denounce your citizenship, you have to fugitive from justice, whether you are or not, whether you're a drug addict, whether you're under an indictment or information on another charge or a felony for which you could be sentenced for 1 year imprisonment, any other state law, Class A misdemeanors, whether you were dishonorably discharged under the military, under a military court charge or indictment under the Uniform Code of Military Justice, or whose charges have been referred to a general court-martial, convicted any court, including a military court, of a felony or any crime for which the judge could have imprisoned you for more than 1 year, even if you received a shorter sentence, including probation. And then on the form also, in order to purchase, you have to declare whether you're unlawful user or addicted to marijuana or any other depressant, stimulant, narcotic drug, or any other controlled substance. And the use or possession of the marijuana remains unlawful under federal law, regardless of whether it's been legalized or decriminalized for medicinal or recreational purposes in the state in which you reside. So the bill, as we review the bill, didn't have any restrictions that we could see that would keep that in balance with purchasing the weapon, even though you could possess the weapon, if that makes sense.
You said they have to denounce citizenship if they do.
Thank you,
I'm
Mr.
sorry,
Chairman.
I said denounce citizenship, but that means if they did.
If they had denounced
denounced citizenship.
Thank you. So my understanding of what you just said then, whether or not I'm legally allowed to purchase a gun, I own many guns that I never purchased. I inherited them from my father, my grandfather, other members of my family. I've purchased other guns legally, but the majority of my collection was given to me. So if I was a convicted wife beater, domestic assault, 3 DUIs, I'm carrying my handgun, long gun, anything else down Main Street in Dixon legally under this bill. Is that correct?
That's my understanding of the way the bill's written, yes.
Okay. Thank you.
Thank you. Commissioner, you have other comments?
No.
Okay. Any other questions? Representative Griffey.
Thank you, Chairman. Thank you, Commissioner Long, for being here. It's a pleasure to see you again. I always enjoy seeing you, and you know I'm a strong advocate of law enforcement. I'm also a strong advocate for the Second Amendment, and it appears to me that what we've really got kind of going on is a policy debate as to where we're going to draw the line, who should be allowed to carry a firearm or a weapon. And I did want to address one point. You mentioned that the current proposal by Chairman Sexton leaves out a bunch of the provisions of, specifically who is or is not allowed to carry. And I wanted to confirm it's your understanding that even if we pass this and you believe it doesn't cover some of the folks that we don't want to have a gun, is it not accurate that federal law 18 U.S.C. 922G would prohibit anybody from carrying a firearm or possessing a firearm who's a fugitive from justice, is an unlawful user or addicted to any controlled substance, has been adjudicated a mental defective, or who has been committed to a mental institution, who is an alien and illegally or unlawfully in the United States, admitted as a non-immigrant visa, who has been discharged from the armed forces under dishonorable conditions, anyone who's renounced their citizenship, and anyone who is subject to a court order that was issued after hearing, which the person received actual notice and had an opportunity to participate, that restrains a person from harassing or stalking or threatening an intimate partner or person or other such intimate partner or person. It also includes a finding that the person represents a credible threat to the safety of such intimate partner and is attempted to use or threatened to use physical force against such intimate partner, or anyone who's been convicted of a misdemeanor crime of domestic violence. The federal law would still be in place even despite what we would do, and someone could still be subject to prosecution under federal law. Is that your understanding?
Yes, a lot of those that you listed are on the Alcohol, Tobacco, Firearms Form 4473, which is firearms transaction record. It would still be inconsistent with our law. If that is the federal law, then as the law is proposed in the bill, it would still be inconsistent with our law.
Okay. And it would be up to the feds if they were going to prosecute those things,
Absolutely.
and
Absolutely.
we may not take them up in state court. And let me ask you that: do you know how many prosecutions there have been in the last 10 years on this unlawful possession of a weapon in the state court? Being chased, I don't mean to play a gotcha. You may not have that statistics off the top of your head. I understand that.
No, sir, I don't. I'm sorry.
Well, there's no need to apologize for that. And so when we come down to sort of considering the policy debate, where we draw the lines, I would just ask for your comment that, the criminals that get possession of a weapon and commit a criminal act, there's nothing we can do to really stop them until we catch them and do something. Mm-hmm. And if we prohibit lawful citizens and people who are simply trying to protect themselves from the bad actors out there, are we not disarming them and taking away their right to protect themselves or family? And the unlawful criminal lawbreaker, he's at more of an advantage over the lawful citizens who's simply trying to comply with the law. And just if you have any comment to that, please.
Yes, sir, I understand that argument, Representative Griffey, and luckily that's the decision of this body to set the law in Tennessee and establish how y'all want the law to be. Yes, sir.
Thank you. Thank you, Commissioner. Thank you, Chairman.
Leader Lambert.
Commissioner, again, deeply appreciate your expertise, and I know you yield to us on kind of policy decisions, and I've always appreciated that perspective as well, because that is the proper role of this, for us to set policy, for you guys to help us and guide us in that. You mentioned something a while ago, and Representative Griffey mentioned this as well. In taking out those federal prohibitions that have been cross-referenced in our code previously, with this bill as written, and I actually very much support the concept of this bill. I like the idea of kind of flipping this around where the default is that you have a right to carry, except for those criminal individuals and others that are prohibited. By taking that cross-reference out, would it then, in Tennessee at least, under Tennessee law, allow for illegal immigrants or federally prohibited individuals would it allow those folks to carry?
Yes, sir. As I reviewed the bill, it would, yes.
All right, and is there and I'm not saying we do this today, but at some juncture, just in your experience, is there could there be an easy way to graph that back in, just with a cross-reference to the code that Representative Griffey had mentioned, where those individuals that are prohibited under federal law from carrying, we could also still prohibit under state law, with the understanding that, again, we're saying all law-abiding citizens can carry, and we're just outlining that, look, if you're federally prohibited, you're still prohibited here. That's what the current law is in essence, right?
That's what the current law is, so yes, that would be the way to do it, yes.
Okay, thank you, Commissioner.
Thank you.
Thank you. Any other questions? Representative Sexton.
Commissioner, I appreciate you being here today as well. I appreciate your expertise and the work that you do for all of Tennessee. And I know that I don't doubt that you have every intent to do the best that you can for Tennesseans and for this state.
Thank you.
I deeply believe that, and I appreciate the work that you do. I appreciate your department and what it does. The intent of this bill is very simple. Right now in the state of Tennessee, if I leave my home with a firearm, I'm committing an offense. Is that correct?
If you're carrying it for the purpose of going armed, yes.
Okay, so if I leave my home with a firearm, I'm committing an offense.
Only if it's a long gun in Tennessee. I think that's the offense
So
now.
excuse me, I'm sorry. If I leave my home with a rifle in Tennessee, I'm committing an offense.
Unless, as I remember it, and please, I'm trying to think of the different laws as they've been amended. There was one at one time where you had to remove the ammunition and have it separate from the gun and such for storage. So I think that's still in effect, but I'm not absolutely sure.
So the intent of this bill is to make it for law-abiding citizens, such as my wife. She has a carry permit, and she carries. She carries, well, I won't get into all that. Those of you that know my wife know where I was going with that. But she finds herself, and I insisted that she get her carry permit so she could carry. And she finds herself much more safe, knowing that she has the ability to carry a firearm. In this case, it's a revolver. But under current Tennessee law, she's breaking the law. And my intent is to, you're shaking your head no,
Well,
so I'll give you a chance to.
I'm sorry, I didn't mean to interrupt you. I'm waiting
No,
for
that's
you.
okay. That's okay. You can go ahead and comment on that.
Go ahead. Let me hear the facts, then I'll.
And the intent of this bill is to change that, to say that if she is going with the intent to go armed, which I don't know why you would carry a firearm if you weren't. In case of a defense, if she's not armed and she's not carrying to go armed, then it really makes no sense to carry it. If you have to remove the ammunition from the gun, or if you have to keep them separate, it really makes no sense, in my opinion, to go armed. But the larger argument is that it's against the Second Amendment, that we have the right to keep and bear arms, and this right shall not be infringed upon. Seems to me that Tennessee law at present is going against our Second Amendment, and I would like to change that to where that, yes, I go armed with the intent to go armed, and I don't want that to be an offense, and to be able to be prosecuted in the state of Tennessee for carrying out my Second Amendment rights. Now, parks and recreational areas is another place of contention. If you have a permit, you can carry in parks. If you have a permit. Is that correct?
It's not fully. If there are children present conducting school activities or things of that nature, a permit holder cannot carry in that situation. You can only carry if there are not school activities going on in that park.
Okay, so that goes to another question. What do we do with our firearms if we're abiding by the Second Amendment and we have the right to keep and bear arms? What do we do with them? Do we find a storage locker somewhere and leave them before we go into the parks? And what if there's someone that tries to steal your child, rape your child, or whatever? Where is your defense once this happens? I'm at a loss to understand how that if you go into a park and the only way that you can carry is if you've got a constitution or if you've got a permit issued by your department. And by the way, let me go on the record to say that this does nothing to stop your department from issuing carry permits. And we still want to do that. I have one, and I'll continue to have one because when we go to other states, we need that. But I understand safety, and I appreciate safety. But as a father, a grandfather, and a great-grandfather, I want to have the ability to protect my family at a time where I've never had to shoot anyone. I've never been in a conflict with anyone. But I've got enough guns to start. No, I won't say that. I've got a lot of guns. But I've never had to use it in a defensive manner. But I'm ready to if I need to.
Yes, sir. As I said earlier, Representative Sexton, our concern is for those individuals who might not meet the standard of what needed to be in order to carry the firearm. Your wife probably is not one we're concerned about. It is those we're concerned about who have denounced their citizenship or who are a fugitive from justice or who have been convicted of some type of assault or some kind of stalking or judicially committed or mentally defective. Those are the ones that we're concerned about that I don't see in your bill that we have in the other federal legislation, some of the others, and you don't refer, as I read your bill, I don't think it referred to federal guidelines or law. So that is not covered in your bill as I understand it.
And I wanted to clarify one thing that was asked initially before we forget. You posed the situation of your wife carrying her revolver. She doesn't even need a permit to do that under current law, so she would be allowed to do that still. There's nothing prohibiting that right now.
But she couldn't go with the intent of being armed.
Yes, she can.
Not according to Tennessee law.
Constitutional carry, yes. That was passed last year.
It didn't take this out.
I think legal may be able to clarify, but that is.
Thank you. We'll go to legal services.
Michelle Fogarty, Legal Services. Under 3917-1307G, it is an exception to the application of subsection A, where it states a person commits an offense if they carry with the intent to go armed. It's an exception to that if they can carry a handgun open or concealed as long as they are at least 21 years of age, lawfully possess the handgun, and are in a place where they are lawfully present. So subsection G is an exception to subsection A.
There's an exception.
You have a question for legal or?
Yes.
Okay.
Okay, there is an exception, but there has to be, you have to understand what those exceptions are. Is that correct?
So that means a person does not commit an offense who is carrying a handgun openly or concealed as long as they are 21 years of age, they lawfully possess the handgun, and they are lawfully present in the place where they are. So that means they are not committing an offense under 3917-1307.
What does it mean when it says if they are lawfully where they are?
Not criminally trespassing.
Is that all?
Well, it's lawfully present. That would be, I mean, if you're trespassing, you're not lawfully present. Yeah, violating a court order.
So you're saying that my argument, which is currently under TCA 3917-1307, that says a person commits an offense who carries with the intent to go armed a firearm or a club. You're saying that's not on the books, not in statute.
Yes, sir, that is in the statute. However, it is an exception to that, or it's not an offense if you carry a handgun openly or concealed, and you are 21 years of age, you lawfully possess the handgun, and you're in a place where you are lawfully present.
So I get it now. You're talking about a handgun and not a firearm.
Yes, sir.
Okay. Thank you.
For legal, Leader Lambert.
Thank you. And it might be helpful, if you don't mind, I mean, to just kind of from a 30,000-foot view, talk about the difference between an exception or an affirmative defense. I mean, because to me, and please tell me if I'm stating this right, an exception to the law means you are not charged with that crime. And again, I like the structure of this where it flips it upside down and it makes it crystal clear what is prohibited. But an exception is, that's going to be evaluated before anybody's charged, and it makes it truly an exception to the law. An affirmative defense is more that person has been charged, and then in court, they have to kind of prove that affirmative defense. Is that a fair description of the difference between the two?
Yes, sir. That's the difference between an exception and an affirmative defense.
Okay, because sometimes I think we get, I'll leave that for discussion on the bill, but I think sometimes we get the two of those kind of intermingled, and they're very different. So thank you.
Another question for legal.
Yes, sir, go ahead.
So could, under these exceptions, a person have to defend themselves in a court of law and lose time from work, hire an attorney? Is that possible?
Subsection G is an exception, so it is not an offense. Someone cannot be charged with an offense under 3917-1307 if they are carrying a handgun and they are 21 years of age or older, they lawfully possess the handgun, and they're lawfully present in the place where they are. So they cannot be charged with an offense under that statute.
And you just have to forgive me, I'm not an attorney, so sometimes this language is hard to comprehend. But again, we're talking about a handgun and not a firearm. Firearm being a rifle, a shotgun, a handgun. We're only talking about handguns. It would still be against the law to carry a rifle or a shotgun. Is that correct? With the intent to go armed.
Yes.
Thank you.
Yes, sir, Representative Howell.
Thank you, Mr. Chairman. While we're talking to legal, could you define for the committee that term, intent to go armed? I'm just curious because, like probably the majority of the people in this room, I have a permit, but under state law, I don't have to have a permit in Tennessee if I wanted to carry a gun concealed on my person. So clearly I wouldn't be carrying it if I didn't intend to. So what's the distinction there? What's the definition?
The term is not defined in law. However, under 3917-1308, it is a defense if you are carrying an unloaded rifle, shotgun, or handgun. So I think it's been interpreted to mean an intent to go armed would mean a loaded firearm. Or it also applies to intent to go armed with a firearm or a club. So it has to do with what you intend to do with the club or the firearm.
Excuse me, Mr. Chairman, I'm still confused. So I intend to carry my weapon on me, like most everyone else, and I intend to keep it loaded, have the safety on. So are you saying I could fall under that definition of intent to go armed?
Not if you're carrying a handgun and you're carrying under the exception that we just talked about. You're 21 years of age, you possess the handgun lawfully, and you're lawfully present where you're supposed to be. Then you would not be committing an offense if you carried a loaded handgun.
Okay, one more question and I'll hush. So I'm a member of a gun club. It's excellent shooting ranges. They have several ranges. And I often will take my long guns, and I have a few of those, to the range. And if I should make a mistake and leave some ammo in one of the long guns as I transport it in my trunk to the shooting range, would I be guilty of breaking the law?
That is a defense under 3917-1308. It's a defense if it's incident to lawful hunting, trapping, fishing, camping, sport shooting, or other lawful activity. So that would be a defense.
Okay. Thank you, Mr. Chairman.
Thank you. Chairman Russell, you got a question for legal?
Thank you, Mr. Chairman. And just to be clear, legal, 3913-1307 has the language intent to go armed because it addresses two issues. One, it defines who can't carry a firearm, and second, it defines who can. Is that correct?
Could you repeat that?
I'll try. 3913-1307 has the wording intent to go armed because it addresses two issues. One, it defines who can't carry a firearm, and number two, it defines who can carry a firearm.
It creates the offense of carrying a firearm or a club with the intention to go armed. So it's based on the person's intent, which is a factual determination based on the individual circumstances. And it also lists an exception to that offense under G, and also I believe there's also an exception about carrying or possessing a firearm in your motor vehicle or boat.
Okay, so that's correct. It does two things. It allows people to carry firearms and also does not allow people to carry firearms. It's just the way the wording is. Is that correct?
Yes.
Thank you.
Any other questions for legal? Thank you very much. Chairman Howe, you raised your hand earlier before we spoke with legal. Did you have a question or comment for the commissioner?
Yes, thank you, Mr. Chairman. And thank you, Commissioner, for being here. Appreciate your service to the state of Tennessee. I just wanted for clarification. As your office has reviewed this bill, would, in your opinion, would it leave any safeguards in place that we passed last session with regard to this issue? Such as, I'll give you an example, such as individuals with a known mental illness under a doctor's care.
No, it would not cover that, no.
So this bill would remove that, is
Yes.
what you're saying?
Yes, as we understand the bill. It would remove that restriction.
Okay. Thank you, Mr. Chairman.
And everything. You asked about everything. It would remove everything you put in place last year.
Thank you, Mr. Chairman.
Thank you. Representative Hardaway.
Thank you, Chairman. And I was actually going to ask legal a question about intent on whether that, when we're dealing with long guns versus sidearms, whether there's a difference in the proof that's needed for intent to go armed.
Legal Services.
Michelle Fogarty, Legal Services. There's no difference in the intent. Intent is something that's for the trier of fact to determine, and it's based on the individual circumstances of each case. So the trier of fact would look at the facts of those circumstances and determine whether or not there was an intent to go armed, whether it was a handgun or a long gun or a club.
Thank you, ma'am. So if I'm going hunting, I intend to be armed. How do we accept out of that?
Lawful hunting is a defense under 3917-1308. It's a defense to the unlawful possession or carrying of a weapon.
Okay, so it's all about we're back to intent on what my intentions are to do with the weapon. And I understand the difference between the exception and the affirmative defense. If I'm going hunting and I find the need to defend myself, what do I have there, the exception or the affirmative defense?
Well, it would depend on the facts. You could also use the justification defense under 3911. Let me see. It's 3911. 611. So it depends. It depends on the facts of each individual case. But there is the justification of self-defense, which is in Title 39, Chapter 11, Part 6. But if you're just carrying incident lawful to hunting, then that is a defense to the offense of unlawful possession or carrying of a weapon.
All right, thank you, ma'am. Mr. Chairman, I think I've contributed enough confusion to this matter.
Well, thank you for your contribution. Representative Griffey.
Thank you, Mr. Chairman. Commissioner Long, let me ask you this from the department's perspective. Would it go a long way at easing some of the department's concerned if perhaps an amendment was added to Chairman Sexton's bill that cross-reference any disability under the federal law under 922G? Therefore, if you're prohibited under federal law under 922G, any of those provisions, illegal alien, the stalking, all of the incapacity, incompetence by court order, if it cross-reference all those, would that address some of the department's concern? I know we're still probably going to have a philosophical argument on the 18 versus 21-year-old long guns, handguns, but am I hearing the department's major concern is the current bill doesn't address all the prohibitions that you feel are necessary that are also contained under federal law? Is that a fair summary?
Yes. As I see the bill, the federal guidelines are a large part of it. There are some state concerns of also state law that's not included in the federal guidelines, but the federal guidelines have the majority of the things listed, yes.
Thank you, Chairman.
Any other questions? Representative Sexton.
Just for the record, Commissioner Long, it was never the intent to remove anything that was on the federal level in this bill.
Okay.
Our intent is to just make us more in line with the Second Amendment. Mm-hmm. Sure, you know, there's certain people that lose their rights or don't have a right because of, you know, the unfortunate birth defects or whatever, you know, mental or whatever the case might be. I understand that. That's not the intent, never was the intent of this bill.
Okay.
So we would be completely fine with the recommendations that Representative Griffey's made.
Thank you.
Representative Hardaway.
Thank you, Mr. Chairman. I'm going to add my contribution. Commissioner, are you offering an amendment to improve the bill, or it's not possible? Where are we on that?
I believe that over the weekend or week, Representative Sexton called Ms. Stroker, and she told him the issues that we have with the bill and what would need to be changed in the bill. So he's been provided that, is my understanding.
And I can speak on that conversation, but an amendment we would need to make us not opposed would just be keeping the law mostly as is.
Well, I guess that's simple enough. Thank you, Mr. Chairman.
Thank you. I do have a question for y'all. Let me write this name down. 3917-1307, Section G. If we were to change where it says handgun to firearm, and then you go down to H1 and change, or excuse me, stay in G and go down to Section 2 there and change handgun to firearm, what would that look like as far as?
It still would not have the federal suggestions in the bill if that's the only thing you did, sir.
And H1 says firearm already. It doesn't say handgun.
Right. Well, I meant to. I said H, but I was saying G. In G right there, it's an exception to the application of subsection A, person carrying whether openly and concealed. If you change that from handgun to firearm. And then if you follow down and still in section G2, a person lawfully possesses the firearm instead of handgun where it says currently in code.
Are you saying that would be the only thing the bill would do, or adding that in?
Well, if we change those words, that verbiage in the code that's currently present right now, what would that look like as far as what the intent of what the representative is trying to do with this bill compared to what I just asked? And it's just for my curiosity.
It wouldn't change any of the other problems if we're talking about just adding that in as well.
Current law.
Yeah.
If you just put that in the current law, the current law.
Are you saying that alone on its own be the only thing that's changed?
But you still wouldn't be able to carry if you're stalking, DUI, all the other issues.
Under current.
Correct.
And that's
That's
some of the
issue.
issues that you have
That's the issue.
now.
Yes. Yes.
So if it was changed from handgun to firearm, those persons still would not be eligible to carry. They were convicted of stalking. So that would address some issues
Yes.
at that point,
Yes.
just by changing those two words.
Yes.
Let me go to Leader Lambert first. He had his hand up before you did, and I'll come back to you.
Thank you, Mr. Chairman. You covered most of what I was going to ask. I mean, the only real, just kind of thing I just want to address, I mean, Commissioner, if the statute remains the same where those that are prohibited now are prohibited after this bill from being able to carry them. So those individuals that are stalking, those individuals that are convicted of stalking, those individuals that are convicted felons, those individuals that are, again, prohibited under federal law, I mean, all of that, if it literally is just a legal change where instead of having exceptions, which, again, I agree with legal, I think it is tantamount to the same thing, but just to clarify it up so that it says, look, you may carry except these are the prohibitions. Do you guys have any, opposition to just changing the way the statute reads so that it's clearer?
No.
Okay. All right. Commissioner, thank you. And again, it sounds like we're going to come to the end of the testimony. I, again, want to say thank you for being here today. And I personally found this very helpful. It's just a back and forth. And, as one of the most experienced law enforcement officers in our state, just thanks for coming down. And we always, again, are glad to see you. But this has been very interesting. So thank you.
Thank you. And I will say, Leader, 49 years of law enforcement, I'm about to get to a point where I don't know what the law is on possession or gun or anything else anymore without going.
By the way, when I said 4 decades, I didn't mean to short you a decade. I apologize. 5 decades. My bad.
Last question we'll have, Representative Griffey.
Thank you, Mr. Chairman, and thank you again, Commissioner Long, for being here. I just wanted to comment. I think you can see the argument from some of the Second Amendment folks. Say Chairman Howell or I, I live out in the country. I don't know about Chairman Howell, but if I want to walk down the road, go dove hunting at my neighbor's field, and I load up my 12 gauge and I put it on my shoulder and I'm walking down the road, technically I could be charged. And all law enforcement officers are the best folks in the state, and I mean that when I say that. And they're going to do what we say the law is, and they're going to follow it to the T. And they might say, I'm sorry, but you got to be charged, and you'll have to go to the court and talk to the DA because that's an affirmative defense, and you'll have to prove, you weren't, you had the hunting deal. And so a person could technically have to go through court and all that, and all I was doing was walking down the road to go to my neighbor's field and dove hunt. So I think that's part of the issue that a lot of the Second Amendment folks and hunters are concerned with. And so I hope we can address that. And I'm sure you can appreciate where they're coming from on that.
I was raised in rural West Tennessee, so I clearly understand it.
Thank you, Chairman. Thank you, Commissioner. Thank you, Chairman.
All right, thank you. Thank you very much for your time and for being with us and answering questions. Yes, sir. Yes, sir, Representative Sexton.
I just want to say again that I do appreciate the work that your department does. As Griffey just said, some of the best and the finest, and we feel safe in Tennessee. We just have a philosophical difference when it comes to the Second Amendment. I want, to have the freedom, and my constituents do, and 68% of Tennesseans would like to
We understand
see
that,
a change
Representative
that.
Sexton.
But I do appreciate everything that you do, and I appreciate you coming today.
Thank you.
Thank you.
Thank you.
Thank you very much.
My excuse, Chairman.
You are dismissed. Yes, sir.
Thank you.
Next on our list, we have Jimmy Music from Sheriff's Association, if he's here. And he walks. And we'll let Patrick Powell from the TBI also join you there. Whichever one wants to go first, you'll have 4 minutes for your testimony, and then what we'll do is we'll have one of you speak, the other speak, and then we'll open it up to the committee to speak to either one of you. But whoever wants to go first, introduce yourself. You have 4 minutes.
Thank you, Chairman. Patrick Powell with TBI. I don't think I'm going to take 4 minutes. We're largely just going to echo safety statements. Did a deep dive on the bill last night. Agree with their conclusions that this would prohibit state law enforcement from acting or prohibiting people convicted of stalking, people who've been adjudicated mental defective, people who've had DUI convictions, illegal aliens, people who've renounced their citizenship, et cetera. Wanted to make the body aware of those impacts that the bill would have, and that we have concerns that that would impact, obviously, public safety. So with that, I'm happy to answer any questions.
Thank you. Any question? Or I'm sorry. Never mind. Going to you. Thank you.
Good morning. Jimmy Music. I represent the Tennessee Sheriff's Association. And I want to be really clear about one thing. So the sheriffs of Tennessee, all 95, are in an association. And frankly, when we get together, we don't all 95 agree on what to have for lunch, let alone on a particular bill. But we did follow the same process on positioning this bill as we do others. We have a legislative committee made up of over 40 sheriffs, and they vote. And so where we came down on this one, because, and I've listened to the debate some this morning, I understand what Chairman Sexton's saying, that it was not the intent to remove those things. That was the bill we had to go off of, and so that's what we voted on. Clearly, the sheriffs of Tennessee value the Second Amendment, and they're supporters of the Second Amendment, but with removing some of those prohibitions as a state offense, it was obviously very concerning to them. So if there's an additional amendment to come, we're happy to review it and come back to you, but all we had to go on was what was filed with the committee today.
Thank you very much. Questions for our guests? Representative Howe.
Thank you, Mr. Chairman. So just to clarify, Mr. Music, if those were put back in, such as stalking, mental illness, domestic abuse, the things that this bill appears to eliminate, if those were put back in this bill, would the Sheriff's Association be okay with that?
I don't know, because we haven't considered that. We went off what was in there. I think that the extension of to the word firearm obviously is all-encompassing and bigger than handguns. So I don't know. I can't tell you how much that was the sticking point versus those pieces. I will say, though, and I understand that it's confusing. It's confusing for me even to read that when you've got an offense, you've got exceptions, and you've got affirmative defenses. I don't think any of us on the sheriff's side would have an issue that you converted. I think as Representative Griffey was stating, you convert those affirmative defenses to exceptions. That's fine. I don't see an issue with that. I think the way it's played out is leaned on officer discretion on your hypothetical going dove hunting, that, clearly that's a defense. People know you in your community. You're going to your neighbor's field. They confirm it. They're probably not getting charged, but I understand that if you had an overzealous officer or deputy that did charge you, that would create issues for you to have to defend yourself, assuming the DA would seek to prosecute that charge.
Thank you.
Any other questions for our guest? Representative Hardaway, you have another contribution?
I do, sir. I never want to disappoint. Okay. And good morning, gentlemen. Real simple question. Would TBI, with the Law Enforcement Sheriff's Association, et cetera, would their safety be impaired by the passage of the bill? Or would it be enhanced by the passage of the bill?
And Representative Hardaway, just to make sure I'm understanding the question, are you asking about whether or not we believe this would impact law enforcement officer safety?
Yes, sir.
I believe we think the bill as drafted would impact law enforcement officer safety and public safety.
And you, sir?
The amendment that we have, obviously, if you have felons or people who have been adjudicated mental defective that are allowed to carry under state law, sure.
Mr. Chairman, all these law enforcement officers especially TBI and Tennessee Highway Patrol troopers need a raise.
I agree. Thank you. Any other questions for our guest? Seeing none, thank you all very much for your time. Next on our list is Toby Meyer. If you would introduce yourself, you'll have 4 minutes for testimony and then questions.
No, ma'am. Thank you, Mr. Chairman. Thank you, committee members. I very much appreciate all of y'all, and I want to thank the Department of Safety and the Sheriff's Association for that as well, trying to get it right. This is very important because when it comes to criminal law, if anybody gets it wrong, they may end up in prison or they may end up in jail. And if we are having such a hard time figuring out what certain terms mean, we can only imagine how this is going to be for the average person out there. The first thing that I want to point out is that oftentimes terms are defined differently in law than we use them in everyday language. So for example, the term exception, we usually believe to mean that something is not covered by the law. But that is not the case. So specifically, if you look up TCA section 39.11.202, exception is defined as actually something that the state does not even have to negate in trial. So counter to what you would expect, an exception is actually weaker than a defense, because defense is defined in TCA section 39.11.203 as something that the state actually has some responsibility to look into. But as Representative Sexton correctly pointed out earlier, you can still get arrested and charged and indicted for the crime of carrying a firearm, including a handgun, with the intent to go armed the moment you leave your house. And then in court, you can raise the defense, according to 39.17.1308, that you have a carry permit. The court will look at the carry permit and the charges will be dismissed. But at that point, you already have your mugshot in the newspaper, you already have an arrest record, you have legal fees that you won't get reimbursed for. Obviously, that's one, a waste of state resources, and two, putting people into trouble that they shouldn't be in, and three, it makes the law inconsistent what people expect it to be. So that's actually why I appreciate this bill, because it's a great cleanup to the current confusion of the law. And obviously, you know, we all think exception, okay, that means this part is carved out, and that's what we referred to earlier regarding 39.17.1307G, which makes carrying a firearm, if you are not prohibited from carrying a firearm, an exception. But again, an exception is something that the state doesn't even have to look into in the same depth as a defense. Sorry that it's confusing, but I appreciate this bill actually getting away with this trouble. Then I also want to point out that there are actually several sections, both in state and in federal code, that do address some of the concerns that were earlier mentioned. One is TCA section 39.17.1302, which lists various prohibited weapons. That remains unaffected by this bill. So if you carry any of those dangerous lethal weapons, that is still illegal, even if this bill passes. TCA section 39.17.13.16 addresses various prohibitions on sale and purchase of firearms. That also remains unaffected by this bill. As Representative Griffey, thank you for that, correctly pointed out, Title 18 United States Code section 922G lists the prohibitions that were discussed earlier for example, people who are illegal aliens, people who are adjudicated mentally defective, people who are fugitives from justice, and various other parts. And one thing that I think is important, I've heard this oftentimes, this concern that state law would have to mimic federal law. That is not the case. Y'all are in charge of state law, and y'all are exclusively in charge of state law. DC does not have the authority to tell you what you can and cannot do. Now, if state law ends up in conflict with federal law, then if this is within the area, am I reaching my time?
You have exceeded your time, yes. Thank you.
Thank you very much.
Any questions for our guest? Seeing none, thank you for your time and testimony.
Thank you, Mr. Chairman.
We have also on our list Joe Stats. No, ma'am. Well, all right, with that objection, we'll go back into session. We're back on House Bill 2524 as amended. Representative Griffey.
Thank you, Mr. Chairman. Members of the committee, based upon what we've heard today, I would urge that we pass this bill on the full committee with the understanding that we're going to make the amendment that would add back in all the current restrictions we have on prohibited persons in Tennessee, and that we also make carrying a firearm rather than handgun an exception, if you're not prohibited, an exception rather than any of the affirmative defenses. Because I hope we'll address a problem where someone could technically, may not happen, but could be charged for simply walking down the road with a loaded shotgun and they're going to go dove hunting or whatever. They're technically in violation of the law and would have to come to court and prove that they're simply going the hunting defense. Just and look, being in court most of my career, I can tell you it's a burden for people to have to get up and show up for court, take off work, and do all this stuff, and it's not fair to our ordinary citizens who are simply trying to exercise their Second Amendment rights. So that's what I would urge the committee. Thank you.
Yes, sir. Thank you, Chairman Curcio.
Thank you, Mr. Chairman, and I would have to disagree with that. Last Saturday, I was on Main Street in Dixon for our St. Patrick's Day Festival, and instead of celebrating the day, I had a line of assistant district attorneys waiting to talk to me about this bill because we're allowing convicted wife beaters to carry guns if we vote for this. I know that's not the intent of the sponsor, but when we vote for this today to get it out of committee just so we can fix it down the road, that's what we're voting for. So these stories about dove hunting are real cute, and I'm sorry that it's an inconvenience for people who have to go to court, but it's going to be an inconvenience when a child who's been beaten by their father has to deal with him having a gun. So let's fix it in sub, please, so that none of us have to go on record as supporting that. And then if this makes it to full, we can fine-tune it if needed and move it forward. Thank you.
Thank you, Representative Griffey.
Thank you, Mr. Chairman. Look, I'm fine with fixing it in sub if we're going to fix it and come back next week. I don't have a problem with that. But look, my comments were based upon fixing the bill. I'm not voting for allowing somebody who beats his wife or something like that. I kind of think that's an unfair analogy. So thank you, Mr. Chairman.
Representative Hardaway.
Thank you, Chairman. I just want to make sure that we understand that spouses beat each other, and let's not focus a spotlight on one gender or the other. Thank you.
Leader Lamberth.
Mr. Chairman, question for the clerk or whomever can answer this. Has this bill, how many times has this bill been on the calendar? 2 times? So it definitely could be rolled another week. Changes could be made, and it still could very easily pass this committee then. Is that accurate, Mr. Chairman?
Right. Okay. It's possible, yes.
Mr. Chairman, I do share, again, some of the concerns that have been expressed by other members of the committee that, the work of the subcommittee is to make sure that a bill is in its best form before it comes out of a subcommittee. I think there's been some good testimony. I know the full committee chairman, and I say this as a former full committee chairman myself, it is preferable that by the time something gets to a full committee, it is in a very good shape. And that has been, Mr. Chairman, your policy throughout this year. There's been very few bills that made it to the full committee that were not in almost perfect shape. So just food for thought to consider for the sponsor or anyone else. It is normally preferable that we address any issues that, especially of just kind of a legal clerical issue, which some of this sounds like to me. I don't think the intent of the sponsor was to allow for a domestic abuser or stalker or illegal immigrant to be able to carry. I just don't think that was ever his intention. In fact, I know it's not. And so just something to consider.
Thank you. Representative Griffey, brief comment.
Thank you, Mr. Chairman. I'd like to make a motion we roll this bill to the heel of the calendar, and we'll fix it and come back next week. I hope I get a second and everybody agrees.
That is a proper motion to roll to the heel of today's calendar. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. Roll to the heel of today's calendar. Okay. Next item on the calendar, House Bill 2439 by Chairman Farmer.
Mr. Chair, what I was going to do, I'd like to roll this to the hill of today's calendar as well.
Okay.
Second.
All right, without objection, roll 2439 to the hill of today's calendar.
Mr. Chairman,
Yes, sir.
I know I'm out of order. I'd just like to recognize a friend and a guest in the room today, Bradley County Commissioner Kevin Raper. Just joined us. Raise your hand. Glad to have you with us today. Thank you, Mr. Chairman.
Thank you. Next item on our calendar, House Bill 2211 by Chairman Russell. You are recognized.
Thank you, Mr. Chairman. This bill attempts to bring the state back into compliance with the TBI background checks by limiting access to only the appropriate public agencies. Patrick Powell is here to better explain that for us if you'd like to go out of session and hear from him.
All right. Thank you. We'll go out of session to hear from TBI. If you would introduce yourself, you'll have 4 minutes. Out of session.
Thank you, Chairman. Patrick Powell with TBI. This bill was brought by TBI to Chairman Russell. It is attempting to get us back in federal compliance in a couple of different areas related to background checks, specifically related to firefighters and to child care agencies. The FBI occasionally does reviews of our background check statutes to make sure we are in compliance with their regs. They found that we were out of compliance because certain aspects of criminal histories could be shared that were intended only for public agencies could be shared with private individuals. We were simply trying to correct that, make it where only the appropriate agencies are getting access to the criminal histories. With that, I'm happy to answer any questions.
Thank you very much. Any questions for our guests? Seeing none. Thank you very much. Next on our list is Pamela Moses, if she is here. All right. We will, without objection, we'll go back into session. We're back on House Bill 2211. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting on sending House Bill 2211 on the full criminal. Those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Item number 4, House Bill 2677 by Representative Leatherwood. Motion. Second. You have a motion second to recognize. There's also an amendment, Code 15810. Do you wish to proceed with that amendment?
Yes.
Okay, you're recognized on the amendment.
Okay, the amendment does make the bill, and this bill creates an offense for an employer to influence or attempt to influence by means of coercion a public servant employee to vote or not to vote or act or not act in a particular manner. And with that, I appreciate y'all's support, and I'll take any questions.
Well, thank you very much. Any questions for the sponsor on the amendment? Representative Beck.
Thank you, Mr. Chairman. Is this not the law already? I thought, are you talking about, for example, a clerk's office coercing a employee to vote a certain way? I'm not following exactly what you're trying to do, and what is the present law now?
Yeah. If I understand the example, you said a clerk's office trying to influence an employee. You know, I think of as former register of deeds, me trying to influence one of my employees to do something. This would not cover that. This is an employer trying to influence a public official. You know, we are a part-time legislative body. We have a lot of part-time commissions and boards, school boards and so forth that are elected. They're public officials. Being part-time, most of us, not all of us, but most of us have other jobs. And so this would address our employer in that other job trying to coerce, and coercion is defined in the legislation as threatening us up to threatening the loss of a job to try and influence us to vote against or act against our convictions or our constituents. And it's my understanding that it actually is not in law at this point, but I believe it should be.
So this would be more along the lines of retaliatory discharge. Am I following you there?
A what discharge?
A retaliatory discharge. In other words,
yes, against a public official.
Against the employer of a public official.
Yeah, against an employee who is a public official, yes. An employer.
Very good. That. Thank you so much.
Yes.
Leader Lamberth.
Thank you, Mr. Chairman. I did just want to bring members' attention to the fiscal note. It does indicate a $1,200 increase in state expenditures for incarceration cost, which to me normally indicates that it is definitely not illegal already, and we are certainly making something illegal that was not previously. So they're accounting for additional incarceration. Now, not a lot of cases, but at the same time, it still does indicate some increase for incarceration cost.
Representative Griffey.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this. If I understand the intent of the bill, is if an employee works for an employer, whether it's a public or private employer, but that employee also sits voluntarily, part-time, on some board, commission in the state, county, city, municipality, and they're charged with doing what they think's best for all their constituents. And this would prevent an employer from using its ability of hanging a job over somebody who says, I want this decision to go this way or that way, which is the intent of the employer, but may not be best for the constituents in the state, the county, the city, whatever it is. Am I understanding it correctly?
Absolutely.
Okay. I think this is a good bill, and I think we ought to do it. So thank you, Mr. Chairman. Thank you, sponsor.
Thank you. Any other questions for our sponsor? Representative Hardaway.
Thank you, Chairman, and good morning to the sponsor. And I don't know if we need to go to legal or not, Mr. Chairman, but when we're speaking about public servants, is that defined in the law? Are we talking about elected officials, appointed officials?
Yes.
Or is it defined in your legislation?
It's currently defined in law, and then this bill actually adds to that definition. I'll start with what this bill adds to the current definition of public servant, and of course, legal correct me whenever I stray. But what it adds is a nominee, member, representative, or other holder of a position on a board, commission, or public body of the state or political subdivision thereof, which is pretty much exactly the way Representative Griffey described it. In current law, as I understand, present law defines public servant as a person elected, selected, employed, or otherwise designated as one of the following, even if the person has not yet qualified for office or assumed the duties: an officer, employee, or agent of government, a juror or grand juror, an arbiter or other person who is authorized by law or private written contract to hear or determine a controversy, an attorney or notary public performing a governmental function, or a candidate for nomination or election to public office. So that's current law, as I understand it.
All right. Thank you, Chairman. Thank you, sponsor. And that's what I was trying to understand. So you don't actually have to be an agent or an elected official, or an appointed official. It can be in advance of you actually acquiring the position. So you could be a candidate for a position or an applicant for a position.
I think that would be correct. And I believe with us, we actually assume our office as soon as we win on election night. But in many other positions, you may win, but you don't actually assume the position until a certain date or until you're sworn in.
Mr. Chairman, I guess legal might need to answer this out of session, whether it would take into account applicants for a job, not nominees or candidates for an elected position, but applicants for a position.
All right, thank you. We'll go out of session. Hear from Legal Services.
Michelle Fogarty, Legal Services. The bill defines employee as a person employed by the state or any local government entity, board, commission, agency, political subdivision, a person employed by a private employer, or a person who receives compensation from the federal government for services performed for the federal government. So it does not include applicants.
And is receiving compensation a condition that makes a state or another local government entity bringing them into the fold for this legislation?
No, sir, that language is only as it applies a person who receives compensation from the federal government. Employee is defined as a person employed by the state or any municipality, county, department, board, commission, agency, instrumentality, political subdivision, or any other entity of the state.
Okay, I understand what you've said, so I guess, Mr. Chairman, I have to ask the why question when we go back into session on why we would only use the compensation feature for federal entities, federally employed individuals instead of everyone.
Okay, thank you. Representative Beck has a question for legal.
Legal, is the code silent on this topic as we stand here today?
Specifically, what topic?
Specifically, someone trying to influence a board member or a political subdivision of the state.
It's silent as to coercion of an employee who also serves as a public servant on one of those commissions, yes. But the definition of employee, to Representative Hardaway's question, is, it says includes but is not limited to. So there is some, it includes but is not limited to persons who are employed by the state who receive compensation from the federal government. So it's not a closed definition. It's just more open-ended in that it includes but is not limited to. All those that I read.
Very good. Thank you so much.
Thank you very much. Any other questions for legal? We're going back into session. All right, Representative Russell.
I don't know if it's for legal or the sponsor, but does this affect the Hatch Act, or does it have any thing to do with the Hatch Act or the Little Hatch Act?
I would think not. As I understand, the Hatch Act prohibits some federal, and then I think there's a Little Hatch Act or something for some states. It prohibits employees from participating in certain political activities. So I don't think there's an overlap here, but again, I defer to legal if they have anything to add or correct.
Representative Russell, do you want to go to legal for that answer, or is that sufficient?
Well, that's sufficient. She was shaking her head no, so I think that's fine.
Okay.
That's right. We were all watching what she did.
Leader Lambert.
Move previous question.
All right, question's been called. Any objection? Seeing none, we're voting on on the amendment. We're on the amendment. We're voting on adopting Amendment Code 15810 on the House Bill 2677. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 2677 as amended. Question's been called. Any objection? Seeing none, we're voting on sending House Bill 2677 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Thank you. Next item, House Bill 2323 by Representative Grills. He is not here. We will roll to the heel of today's calendar. Item number 6, House Bill 630 by Representative Gillespie. You are recognized properly on your bill.
Thank you, Mr. Chairman. I do have an amendment on this bill that makes up.
No, sir, you did not file the amendment with the office.
Ooh.
Would you like to roll to the heel or to next week's calendar?
Roll for the next.
Roll 1 week without objection. Thank you. Next item, House Bill 2789 by Representative Powell. Representative Powell. Without objection, we'll roll 3 spaces. Item number 8, House Bill 2578 by Chairman Dixie. You are recognized. You have an amendment, code 15818.
Yes, sir. Bill.
Second, you're recognized on the amendment.
Thank you. Thank you, Representative Beck, for paying attention over there.
Question's been called on the amendment. Any objection? Seeing none, we're voting to attach amendment code 15818 on the House Bill 2578. All those in favor say aye. Aye. Those opposed, ayes prevail. You adopt your own House Bill 2578 as amended.
Thank you, Mr. Chairman. Thank you, committee. This bill seeks to make eligible an inmate who is to be released on parole upon reaching the inmate's release eligibility date, the red date, they have met the following 4 criteria. Not being previously convicted for an offense other than the offense for which the inmate is seeking parole. Number 2, has not been convicted of a violent sexual offense. Number 3, has successfully completed programming recommended by the Department of Correction based on a validated risk and needs assessment. And number 4, has not received a Class A or Class B disciplinary offense under Department of Correction policy within 1 year of the inmate's parole hearing. This particular bill would help and encourage and incentivize inmates to, from day one, to do right once they get into the prison or the correction system. This will also save the state of Tennessee almost $4 million a year the first year, and then $7 million the next year in incarceration rates. So I'm not going to belabor the point. We all know what the benefits are of getting people back into society. Someone that's proven from the day that they got into prison to the day that they're finished serving their sentence that they are willing to rehabilitate themselves and reintegrate themselves and reintegrate themselves back into society and be a productive citizen. This bill will also help reduce the recidivism rate in the state. So I think that with that explanation, Mr. Chairman, I'd like to ask for your vote.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative Dixie, for bringing this bill, but I'm totally against it. I think this would limit the ability of our probation and parole commission to effectively make the determinations that need to be made. I'm not interested in saving money for the state of Tennessee. I'm more interested in protecting the community. And I think the way we've got it now is working as best it can be expected. I think this bill would be a step backward rather than a step forward. So I'll be voting against it. Thank you.
Thank you. Any other questions? Yes, sir. Go ahead.
I'd just like to respond to that. I think that the way that the bills that we have moved through our chambers the last year, this year, it is a movement toward reducing the probation and parole impact on prisoners' parole. We have bills that are presented going through the system right now that'll basically eliminate probation and parole. So I have to disagree with you on that. I know it's one of the few times that we disagree, but I would have to disagree with you on that. And I think that we also have to make sure the goal is not to put harsher penalties on people incarcerated for longer periods of time, especially when they're doing the things in order to show that they have changed their behavior that got them there in the first place. I think we need to incentivize them and make sure that we do that. It's not about saving money. It's about making a productive citizen and help them reintegrate themselves into society.
Chairman Curcio.
Thank you, Mr. Chairman. I move previous question.
Previous question called. Any objection? Seeing none, we're voting on sending House Bill 2578 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, no. The noes prevail. The bill fails. The bill will be moved to the special calendar. Item number 21 by Representative Dixie, House Bill 2576.
Now, we need a motion. Yep.
You have a motion and a second. You're recognized.
Mr. Chair, thank you, but I don't want to tell you how to run your committee, but I think you need to separate those two over there. Because nothing can get done with those two by themselves over there.
Chair Lady Moody, you have a...
I love my friend to my left, but he was the one doing all the talking, so I just...
You're just a good listener.
She didn't even blow a horn before that bus came.
All right, you recognize Chairman Dixie.
So what this bill would do, in essence, is it would make it a Class E felony for any elected official that makes a knowingly or false or misleading statement about any public health issue. I think this is important for us as leaders in this community, that we get the facts out, that people understand the facts. People look to us for leadership. They look to us to guide them on what's going on in our society. They look for us to make sure that we get the factual information to our communities. It's incumbent upon us as leaders and elected officials that we put out the good information and factual information, and not something that's based on opinion or suspected false information. So we want to make sure that we are held to a higher standard, which I think we all agree that we hold ourselves to a higher standard because we are the leaders in our community.
Thank you for that. Any questions for the sponsor, Leader Lambert?
Thank you, Mr. Chairman, and thank you, Chairman, for explaining that. I'm curious, and we're always in this committee looking to make sure we're not putting a crime on the books that's a solution in search of a problem. So if you could just give us a few examples of public officials that have made statements that would be under this particular bill.
Only when it comes to public health issues. Just even with the pandemic that we've had, people have made false statements knowing that it's not. And when I say a false statement, something that goes against science, that is a proven fact. We can't argue that 2 + 2 is 4. If I tell you that's 5, then we have a problem. So those are the type of things that we want to prevent, to make sure that we're getting the correct information to our constituents so they can make good decisions about their health issues.
Leader Lambert.
So you don't have an actual example?
Oh, there's plenty of examples. I didn't know you wanted one specifically. I just wanted to give you in general. I cannot give you a specific example at this particular moment because I don't have one prepared, but we all know that throughout this pandemic, there's been a lot of false information. For example, when they say that taking ivermectin is a valid vaccine for the pandemic. We all know that is not true, and it's not scientifically proven, and it's not a valid statement.
So if someone took ivermectin, I
didn't say if you take it. I said if we promote it and we don't have the factual basis that it supports that statement, I think that would fall under this law.
I'm not here to argue about ivermectin, obviously, but to say that it's a fact that it doesn't work. When I had COVID 2 months ago, I took ivermectin, and within 24 hours, I was fine. So to me, I think it works, you know. So I don't.
By the scientific trials, things of that nature, there has not been a proven statement, not a fact, that is not a prescribed prescription for this particular that particular virus. I don't want to get into your personal thing, but when you go to look at the CDC or the information that's out there, ivermectin is not at the top of the list for a vaccine for this particular pandemic. Now, we can discuss this pandemic all day. You just asked me for, this particular, an example. This is just the first one that popped to my head.
Well, you said it was a fact, and I just disagree with that it's a treatment option. It's not a vaccine, but it was a treatment option. A lot of my constituents have had that same treatment option prescribed to them in that. But I'll go back to Leader Lamberth. He's got a follow-up question. I just want to address that. Thank you.
Before I get to that, I just wanted to make sure that what you said was a treatment option and not a vaccine. That's a difference in what I'm saying. There's been information out there that people have stated that it's a vaccine, not a treatment option. That's a difference. And I just wanted to...
So elected officials are saying that it is a vaccine?
Yes.
And you can give an example specifically?
I do not want to call names, but in government ops, there was one of our colleagues from in another chamber that stated that. And in several instances, that particular colleague has said this. And I will not, add names, but I think that we can go back and pull the tape to see who that is.
Leader Lamberth.
Thank you. That's why I asked for an example. Exactly this back and forth was what I was looking for. Would it shock you to know that Vanderbilt actually is doing a study right now on ivermectin to see whether or not it is an actual treatment option? That's my point. I don't know if you have another example, but I think that especially coming out of a pandemic in which, quite frankly, I think all of us got very exhausted. It was very difficult to keep up with where the science was. You're not hearing folks deny the science. What you're hearing is folks that are confused about the fact that lots of medical officials didn't know how a novel coronavirus was going to affect our world. None of us could have predicted that. And as we went through it, and everyone struggled together to try to get the best answers to that, to try to come up with a vaccine. And I'm grateful for our former president, President Trump, for coming up with Operation Warp Speed and all of his officials and everyone working together, Republicans and Democrats alike, to have a vaccine that's an option. And now we have several treatment options are out there. So to pick a point in time and take away someone's First Amendment rights, which you and I talked about different civil liberties for years, and we've always been on the same page on this, I was just kind of surprised to see. That's the reason I asked for a concrete example. I was hoping for something hopefully better than that, because I think the back and forth you gentlemen just had is helpful to show that you may have someone that has a personal experience where they share information, as the chairman did, that they truly believe. That someone else may say, well, at this point in time, it is there are medical professionals throughout the land that at different points in the pandemic said, well, if you'll just do this. It wasn't that long ago in these committee rooms, we had folks that were in between speakers cleaning that microphone in front of you. And unfortunately, I think as time went by, it was very clear this was an aerosol-based virus. And so cleaning that microphone was not necessarily protecting you. So I have a real problem with a bill that's going to affect folks' First Amendment rights and, quite frankly, the chairman's First Amendment right to share with folks his personal experience. And you may disagree with that, but that's the debate we have in this country. Are there any other examples, maybe something better that would be less, offensive to the First Amendment? Something that would be a better concrete example? I'm just looking for something here to try to save your bill, and I'm not coming up with anything.
No, and I appreciate you having a conversation with me, because the whole purpose of any bill is not to be adversarial. It's to try to make sure that we have we do what's best for our constituents and Tennesseans. So I do appreciate the back and forth, but I want people to understand that as elected officials, we are held to a higher standard because people look to us for leadership, and they look to us for guidance on certain things. So I do appreciate your First Amendment concerns, and I do hear them. And I just wanted to basically have this conversation to get it out there. But listening to Leader Lamberth, I really do understand what you're saying. So at this point, I'd like to withdraw the bill. Oh, well, sorry.
withdraw.
Mr. Chairman, I had my hand up.
Well, your sponsors just asked to withdraw his bill. So without objection, we'll take House Bill 2576 off notice.
Thank you, Mr. Chairman.
Yes,
I
sir.
apologize.
Thank you. We'll go back to item number 7, House Bill 2789 by Representative Powell. You're recognized. You do have an amendment code 14165. You're recognized on the amendment.
Thank you. The amendment makes a bill, so we can adopt the amendment, and I will be happy to describe the bill in detail.
Okay. Question's been called. We're voting on attaching amendment code 14165 on House Bill 2789. Those in favor say aye. Those opposed, the ayes prevail. You adopt. We're on your bill as amended.
Thank you. So in 2016, we enacted the unlawful exposure statute, and which criminalizes the distribution of nude images of an identifiable person that's depicted without their consent that has been distributed. This bill simply makes it clear that some such instances are covered by law that include distributing an image of an identifiable person engaged in sexually explicit conduct, the definition of the offense of unlawful exposure, adding a definition of identifiable person, and expanding the current language to include sexually explicit conduct as defined under current statute. If I could, Mr. Chairman, I have someone here, it's a constituent here in Nashville that brought me this piece of legislation that would like to testify. She's an attorney and worked in the DEA's office and discovered this problem, if we could. Just a few minutes.
Yes, sir, absolutely. We will go out of session. Thank you, ma'am, for being with us today. If you will, make sure your microphone's on. Introduce yourself for the record. You'll have 4 minutes for comments.
Thank you, Mr. Chairman. Thank you, committee members. My name is Doni Porteous. As Rep. Powell mentioned, I am a private citizen. I am here in that capacity. However, I also work as a legal analyst. This was a situation that I discovered when I was working for the Davidson County District Attorney's Office. This was a new law at that time. We were trying to figure out the contours and how does it exactly work. So there were 2 issues that arrived, kind of like bookend issues, if you will. The language that is used currently in the statute says an image, so that's incontrovertible, of the intimate parts of a person, also that they have to be identifiable. So one situation, we had a judge who refused to continue to hear a particular criminal case where it was a body part, just a solo body part, that was presented as a photograph. And that body part was presented to someone's social media. It was said, "This is my girlfriend," but that was presented to her family, her friends, and her coworkers. So she became identifiable not from the 4 corners of the photograph, but from information that was transmitted with that photograph. I think we can understand that a lone body part could theoretically be anybody, but when you say it's this person and you distribute that image in public, it changes the context. So we're asking that information that is transmitted with the image also is fix the identifiability factor. The second part, we had another situation where, again, social media, someone posted an image. It was a woman engaged in a sexual act with her partner. However, she was fully clothed. So she did not meet the definition of her intimate parts being distributed, although she was clearly identifiable. So we're asking that sexually explicit conduct be included in the language of the bill. 48 states have some sort of what's colloquially called a revenge porn bill, like we have here. 45 of those states include sexual acts or sexual activity in the definitions to cover just the situation. So I'm asking the committee to consider adding this language so we can better prosecute, better protect victims who fall kind of what seems like in between the cracks, but probably are more common than what the law explicitly directs right now. Thank you.
Yes, ma'am. Thank you. Representative Griff, you have a question for our guest.
Thank you, Mr. Chairman, and thank you for being here in your service to the state of Tennessee.
Thank you.
Let me ask you a question. What if someone took a picture of a body part and it wasn't that person? It wasn't their buttocks or something like that, and then post on social media, but it wasn't that person's buttocks, but they said on social media, here's my ex-wife's or ex-girlfriend's buttocks or something. Where would we be legally in that situation?
Legally, it's still not that person. So even if someone does that, their privacy has not been harmed because it's not their image. The additional language is that the image was photographed or recorded under circumstances where the parties agreed or understood that it would remain private. So to go to Google, for instance, and pull off an image and share it, that contract of understanding was never made between those two individuals.
And if we get into dispute about whether some person or picture is a person or not a person, or some of those body parts, or someone engaging in stuff, we just gonna jury question if it comes down to it?
Well, at that point, it's going to have to be the victim that would identify themselves. They would be under oath, and then they would be in danger of being charged themselves with aggravated perjury.
And then a defendant's going to say, no, it's not her, it's somebody else. I mean, we're going to probably, and look, I'm in favor of the bill. I'm just trying to play out all the
Correct.
scenarios if we go down this road. Potentially, we could get in a jury question, is that person in the picture or not? And that's going to be a determination for the jury.
Right, as is any
agreed.
fact-based decision. Yes, sir.
Thank you, Mr. Chairman.
Thank you. Any other questions for our guest? Seeing none, thank you for your time and being with us today.
Thank you very much.
We're going to go back into session. Representative Powell, we're back on your bill as amended. You have any other comments?
No more comments. Stand ready for any more questions.
Okay. Question's been called. Any objections? Seeing none, we're voting to send House Bill 2789 as amended to full criminal. All those in favor say aye. Those opposed, the ayes prevail. You go to full criminal.
Thank you, members committee.
Next item, we are skipping around. Item number 18 by Chairlady Littleton. You are recognized on House Bill 1878.
Thank you, Mr. Chairman. And could I have a personal moment, please?
If you desire,
Quick,
yes, ma'am.
I do desire. I have a shadow today. She is the valedictorian of Stewart County, Grace Estes. I'd like to all make her welcome. Thank you.
Well, we're glad to have you. And you got a guest with you?
Oh, yes. This is our incredible vice principal, Mr. Kyle Mallory.
Welcome, Mr. Mallory. Good to see you.
I didn't see him back there.
Good to see you. Thank you for being with us. All right, Chairlady, you recognized on your bill.
Thank you, Mr. Chairman, for the moment and for hearing my bill. I want to kind of echo what Chairman Moody said the other day about the human trafficking bills and the shared hope, and we have dropped a little bit, but we don't want to be just a number one number. We want to be number one in safety and making our state a safer place to raise our children and for our people to actually live in. So this bill addresses some of those issues with the shared hope. So present law provides expunction provisions that apply specifically to the expunction of a person's public records involving offenses related to the person's status as a victim of human trafficking.
Chairlady, one moment. I'm sorry. I got you confused there. We're on 1878.
Oh, okay.
I apologize about that.
That's all right. I'm sorry. I wasn't paying close attention myself. Okay, this bill, 1878, expands the authorized use of sex offender registration fees by the registering agency to include the investigation of sexual offenses and the purchases of specialized equipment for the use in the investigation of sexual offenses.
Thank you very much. Any questions for the sponsor? Seeing none, we now vote. Oh, Representative Beck.
Thank you, Mr. Chairman. Chair Lady Littleton, are these fees dedicated to the TBI? Are they going to the general fund?
I think to the to the TBI.
Great, thank you so much.
Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're voting on sending House Bill 1878 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you.
Next item, number 19, 2234.
So we are.
You are recognized on that one.
Thank you, Mr. Chairman. I'm sorry for the confusion. Again, I want to repeat that, like Chairman Moody said, that this is a part of the shared hope of the human trafficking. We did fall a little bit below in our numbers, but we don't want to be just number one. We want to be the safest state. It's not a number to us. We just want to be the safest state in the nation with our human trafficking laws and bills, and make it a safer place to raise our children and for our adults to live in as well. So the present law provides expunction provisions that apply specifically to the expunction of a person's public records involving offenses related to the person's status as a victim of human trafficking. Under those provisions, one of the eligibility requirements is that at least one of the convictions must be to be expunged was for prostitution. This bill removes the conviction of prostitution as a requirement for a person to be eligible for expunction of multiple nonviolent convictions of offenses that resulted from the person's status as a victim of human trafficking.
Thank you for your explanation. Any questions for our sponsor? Representative Griffey.
Thank you, and thank you, Chair Lady, for bringing this bill. I just want to understand, so what if someone had, they had been a victim of human trafficking, but they had multiple theft offenses, misdemeanor theft? Would they be eligible to expunge all those?
If it was just a human trafficking?
Well, as I understand it, based on your explanation, was that this removes prostitution as a requirement for a person to be eligible for expunction of multiple nonviolence offenses. So if a person doesn't have a prostitution conviction, but maybe they have been, I understand they have to be a victim of human trafficking to qualify for this expungement, and we may need to go to legal on this. But if they had multiple, say, misdemeanor thefts, would this allow them to expunge all of those as well?
At the moment, they have to be charged with prostitution. The law says now prostitution, but this removes the prostitution and says if they've been human trafficked. If prostitution is not on the record for them, then nothing can be expunged for them as human trafficking.
All right, thank you.
Thank you. Leader Lambert.
So in essence, we're removing that out of the code so that it's not a prerequisite that would have to be proven in order to be able to get the expungement. Someone who was a victim of human trafficking could receive an expungement for different crimes based on their status as a human trafficking victim, as long as it was still related and they met the rest of the qualifications. Exactly. Is that right?
That's right.
Okay, thank you, Chairman.
Chairman Curcio.
Thank you, Mr. Chairman. I think it's a great bill, and I never want to miss an opportunity to honor the memory of Judge Carter, because I remember this was something that we worked on together, which was that these folks don't have a prostitution charge now because they've been human trafficked. So by making that prostitution charge a requirement to get that expungement, it eliminates them from the ability to get it expunged. It's a little nuanced, so I can understand the concern, but I think once you look at it in context, very good piece of work. Thank you.
Any other questions for the sponsor? Seeing none. Voting on sending House Bill 2234 on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman and Committee.
Thank you. We'll go back to item number 9. House Bill 2034. Representative Harris, you are recognized on your bill.
Thank you, Chairman, and to the committee. This bill is in relation to the, again, I guess what we call the dog bill right now, regarding to how we take care of our dogs in the affirmative. I think there was an amendment on this bill.
Well, actually, the amendment, if it's 13511 is one you're referencing, that was adopted previously by this committee. So
Yeah, so there was an amendment added to this bill to make some necessary changes, and so with that, I hope that I can gain your vote.
Well, thank you. Members, we do have some testimony here that has signed up here today. So we will go out of session to hear from Angela Schubert. Schubert, you will have, if you will, introduce yourself for the record, and then you'll have 4 minutes of testimony and then questions from the committee.
Yeah, I'm Angela Schubert from Morris Chapel, Tennessee. This bill is an attempt to ban a humane method of dog restraint. There's no scientific argument given for its purpose. Part D of this bill, by default, would make Joe Farmer an E-felon if he had more than one dog. It also would allow the, under 210, 3914 210, it would allow for rescues to take these dogs from, there's no fix-it tickets available, the definition of water, once water leaves a tap, it is no longer potable. I know they changed it to sanitary last time. Sanitary, animals get debris in their water all the time. That would make it a crime. I had proposed some amendment changes to it. I didn't know if he had received any or if there was any options of discussing any of those. So.
Thank you very much for your comments. Members, do we have any questions for our guest? Seeing none, thank you for your time. Next on our list is Janet Testerman. Janet Testerman. Okay. Pamela Moses. All righty. We will go back into session. We're back on House Bill 2034 as amended. Any questions for the sponsor? Seeing none. I will say that I still have issues and reservations with the bill, just more specifically what you and I had spoken about with chain as not being defined. I have many constituents who will be criminalized under this bill if it passes because of, they go to TSC and they buy the dog. It's a chain link that you use. It's standard. So I just wanted to let you know that I will not be in support of your bill, but I just want to make you aware of that.
Thank you, Chairman.
Yes, sir. Any other questions or comments for the sponsor, Representative Howell?
Thank you, Mr. Chairman. I just have one question. I know that even in my area of Tennessee, there have been arrests in the distant past of charges of cruelty to animals. So we have statutes on the books already. Does anyone know how many statutes regarding cruelty to animals are already on the books? And if this would replicate what we already have? Thank you, Mr. Chairman.
Thank you. Would go to Legal Services for that inquiry. Let me go out of session for Legal Services.
Michelle Fogarty, Legal Services. We have cruelty to animals, we have aggravated cruelty to livestock, and we have aggravated cruelty to animals.
Any other questions for legal while we're out of session? We'll go back into session. All right. Any other questions or comments for the sponsor? Representative Griffey.
Thank you, Mr. Chairman. I'll be supporting this bill because I think it's a meaningful step forward without being overburdening dog owners. What it does is it defines adequate shelter to mean a sturdy structure that provides a dog with protection from inclement weather and with the dimensions that allow a dog to stand up, turn around. A collar means a band of material designed to be around the neck of the dog. A harness means strap of nylon designed to restrain or control the dog. Inclement weather means rain, hail, sleet, snow, high winds, low extreme low temperature, extreme high temperatures. Properly fitted means it's appropriate for the dog size and doesn't choke or bind the dog's normal breathing. And it just says an owner shall not leave a dog outside or unattended by the use of restraint unless the owner has provided the dog access to adequate shelter, an area that allows the dog to avoid standing water and exposure to excessive animal waste, shade from direct sunlight, and potable water. An owner shall not restrain a dog and unattended by the use of a restraint that is a chain, has weight attacks, is shorter in length than the greater of 5 times the dog length or 10 feet, and is attached to a collar or harness not properly fitted. And it makes it a Class C misdemeanor. A second offense would be a Class B misdemeanor, which is the very lowest and the next lowest. And this doesn't apply to the restraint of a dog in public camping or recreational areas, the use of restraint on a dog while the owner or dog is engaged in actively trained in valid licensing issue under the state associated with the use of the dog, the use of restraint of a dog while the owner or dog engaged in conduct directly related to the
Representative
business.
Griffey, I'm sorry, I'm going to stop you up. The amendment did take out some of those things that you're discussing there, that you're reading from.
I thought I had the amendment that was, I printed the amendment out that came, I thought it was in the amendment pack. Oh, yeah, this one doesn't have the number on it. My point is, I believe the bill as amended is a responsible step, and it tries to allow responsible owners as much freedom as possible to continue their uses. So I think it's a measured approach, and I think we ought to pass it. So thank you, Mr. Chairman.
Thank you. Any other questions or comments? Representative Beck?
Thank you, Mr. Chairman. And very quickly, I can see that this bill is aimed toward these horrible puppy mills that put tens of hundreds of pets out in uncorrigible weather and elements, and without the proper food and the proper water and the proper shelter. And I just think this is a fantastic bill. I've been overwhelmed with people asking me to support this bill, and I'm happy to support it today. Thank you so much.
Thank you.
Any other questions, comments? Seeing none, we're ready to vote to send House Bill 2034 as amended on the full criminal law. Those in favor say aye. Aye. Those opposed, no. Madam Clerk, take the roll, please.
Representative Beck votes aye. Representative Curcio. Representative Farmer votes no. Representative Griffey votes aye. Representative Hardaway votes aye. Representative Howell votes no. Representative Lamberth votes aye. Representative Moody votes no. Representative Russell votes no. Representative Sexton votes no. Representative Doggett.
No.
Chairman Doggett, you have 4 ayes, 6 noes.
Thank you. The bill fails. It will be moved to the special calendar. Next item we have item number 10, House Bill 2254 by Representative Harris.
Sure.
You have a motion and a second. You recognize there's an amendment code 14514.
Chairman,
you're recognized on your amendment.
All right, Chairman, I would like to roll this bill to the hill. I have a change that's being made. So.
Okay. Leader Lambert.
Mr. Chairman, at this stage of session, I will say, and this is kind of the first bill that's come up on, the mark calendar indicates there's been absolutely no movement on this in the Senate. So, I mean, if you're going to roll the bill, I would highly encourage the sponsor of the bill and really any sponsor to contact their Senate counterparts and, get bills moving on both sides. Because, we're getting relatively late in session for us to take up bills that are not moving in the Senate. But, Mr. Chairman, I figured I'd at least just mention that.
Yes, sir. Thank you very much, for your comments. You would like to roll, I guess?
Yeah, just roll to the hill.
Okay. Any objection from the committee? Seeing none, we'll roll to the hill of today's calendar. Item number 11, House Bill 2619 by Representative Harris.
And I would also like to request that one. I've already spoken with the sponsor on the Senate side. So be rolled to the hill.
That objection, we will roll to the hill. Item number 12, House Bill 2212 by Chairman Russell. You are recognized. You have an amendment 15193.
Thank you, Chairman. That is the correct amendment.
You are recognized on your amendment.
Thank you, Mr. Chairman. And the amendment makes the bill if you want to add it.
Questions called. Any objection? Seeing none, we're voting to add amendment number 15193 on the House Bill 2212. All those in favor say aye. Aye. Those opposed, the ayes prevail.
Thank you, Mr. Chairman. House Bill 2212 seeks to clarify what essentially some judges across Tennessee are already doing by putting it in writing. This is simply an oversight that is not clearly defined in statute. This bill does not make it mandatory that judges do anything different than they are already doing. Currently, if a person is on probation and commits a new offense, that person is arrested for the new offense and most often bonds out. A couple days later, the probation officer catches wind of the new offense and issues a warrant for that person's arrest. Compounding the problem, the second arrest sometimes happens when the person's at work, often resulting in job loss and increasing the likelihood the person will fail to pay restitution and other fines. This bill seeks to correct the problem by clarifying that judges has the authority to allow probation officers to issue a criminal summons to court instead of an arrest warrant for the new arrest. This action would save taxpayers dollars on incarceration, payroll dollars, and time the officer spends in the booking room instead of out patrolling the streets. With that, Mr. Chairman, I renew my motion.
Thank you. Any questions for the sponsor, Representative Griffey?
Thank you, Mr. Chairman. Thank you for bringing the bill. My question is, I don't understand why we need this bill. I thought the judges retain jurisdiction over the probationer and can order them back in court or not order them back in court. If they're going to do a warrant, the probation officer has to get that signed by the judge, and the judge could say, you know what, I'm not going to do a warrant this time, but I'm going to issue a show cause and make him show up in court and go serve him with a copy of it. So I don't understand why we need this bill.
Thank you for that. And you're correct. The judges has the authority to already do this. However, in current law, it's not defined. So you got judges that doesn't, judges that don't, and the ones that don't says it's not clearly defined. This came from judges, police officers, and just private individuals that brought this to me. And to make it clear, I think we need to put it in writing.
Any other questions for the sponsor on the bill? Question's been called. Any objection? Seeing none, we're voting on sending House Bill 2212 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move on to full criminal.
Thank you.
Item number 13, House Bill 2525. Representative Sexton, do you wish to roll that? All right. Well, I tell you what we're going to do before we move that way. All remaining bills on today's calendar will be rolled to next week. We are out of time, so thank you all for your work today. We will be adjourned.